Welcome to the Cheeley Law Review. My name is Ben Burnett. My guest today is Bob Cheeley, the founder of the Cheeley Law Group. Bob, welcome to the show.
Ben, it's good to see you.
Bob, I want to talk to you today about witnesses. When you consider a case that is actively going to seek trial, I imagine that that is a strategic part of the experience for the plaintiff, correct?
Absolutely. Trying a case is like putting on a play. I went to see Wicked at the Fox a little while back. I was just thinking as I was watching this how well put together it was, and everybody knows their role, the speaking parts and the songs and everything, and to keep the audience engaged. And it's a lot like what we do, only not flamboyant.
Not as entertaining for the average woman.
Right. But I do try to make it entertaining and interesting. And so the way you do that is when you're putting on a story or a play, you've got to have good characters and good witnesses. So I have to tell the story of how the plaintiff was harmed, whether it's a catastrophic injury case or it's a business torts case, breach of fiduciary duty and fraud. So you've got to have good witnesses lined up to tell the story, and my overall philosophy is less is best. Don't put up one single person that you don't absolutely have to have, because I don't want to waste the jury's time, number one. And number two, the more you ramble, the more opportunities you'll give your opponent to embarrass some aspect of your case by questioning the witnesses that you put on the stand. So I always try to go really fast in the trial and put up as few witnesses as possible.
It's not lost on me that you spend a tremendous amount of time preparing your witnesses for the courtroom.
Well, one of the things that I tell my client is they always have to give a deposition to the defense lawyer. And I said, this is good exercise for what trial may be like, but it's different. For one, just bear in mind that the lawyer is taking your deposition so he can find out everything he wants to know and more about you and your claims. But there's a whole different dynamic that occurs in a courtroom with 12 people, jury, and a judge watching. A lot of the harassment that they may try to intimidate you with in a deposition to try to purposefully scare you into not wanting to go to trial and settling the case instead, they're not going to do that in front of a jury. So know that that's something in your favor, is that being in a courtroom is the great equalizer in front of the jury. Secondly, I try to go back over their depositions with them before they take the stand, and I show them these are the areas where they're really going to hone in and question you. I don't want you to change your testimony of what you said in your deposition, but there are better ways to say maybe what you said than the way you said it here in your deposition. And I also talk to them about their demeanor. And I also talk to them about what to dress. I don't want my clients coming in, looking like they're just walking down a fashion runway, particularly a woman plaintiff, a witness I'm going to put on the stand. I want them to be pretty understated in their dress, because you've got women on the jury and how women can be judging other women that they don't know. They really form some opinions about them that guys like us don't even begin to comprehend. And it's only because I've been around the block, been so many times that I've learned, sometimes I've learned the hard way about what to tell your clients and the witnesses what not to wear. So I don't want them drawing attention to themselves by what they wear, and surely don't want them wearing any designer clothing or handbags.
Before you put somebody on the stand, how much time have you spent with your average witness?
Believe it or not, I try to spend only enough time as necessary, because I don't want them to take the stand and be all worked up. I tell them to just be yourself, relax, and tell your story. I won't even tell them the questions that I'm going to ask them sometimes, because I don't want them to rehearse what they're going to say. I want it to be natural. I'm not one of these that's going to get them in an office and keep them in there for 6 hours going over stuff. I mean, people's minds fog over anyway if you try to force too much information into them. I just say, this is something you've lived through, or you've watched it, you're a spouse or you're a friend or sibling of the plaintiff, and just come in there and sincerely look at the jury and tell them the story. Don't use anybody's words other than your own. Be yourself.
How often do you need to utilize expert witnesses that are specific to automobiles or medical issues?
Practically every case.
Do you treat those differently?
Some witnesses, experts I've used, and I know that I don't really have to prepare them for anything.
They know.
They know what to say, and they've done this so many times. They can just take the stand and handle it themselves. The biggest thing you want to alert them to is what you anticipate the cross-examination is going to look like. And if there's anything that they said in maybe a deposition, it's maybe not even in your case, it's some other deposition that they gave in a different type of, or different case, but involving maybe the same product. You want to make sure that they don't say anything that contradicts what their opinions are in this case. It's always good to let them know that you got the utmost confidence in them. And I try to do that with every witness, whether it's an expert witness or a layman. I want them to know I believe in them, and they're going to do just fine. They don't need to get sweaty palms.
The average person, I would imagine, who has never been a witness, like myself, would wander into that experience somewhat nervous. Besides be yourself and dress conservatively, what's your average advice to somebody who's going to potentially be a witness in a trial?
First of all, just envision that you've been asked to come over and sit down maybe at your grandparents' house, and they've got some friends from their neighborhood that they have invited over, and you just want to go in there and sit and talk to them like you would.
Mind your manners.
Yeah, mind your manners. I always tell my client and my witnesses when they're being cross-examined to say yes, sir, and yes, ma'am to the opposing counsel. There's something about that that's so disarming. Maybe this is a secret I shouldn't be sharing, but just saying for a grown man who's in his 50s or 60s to be answering questions on cross-examination, and he says yes, sir, and no, sir to the defense lawyer, it's something magical that happens. It's like jury believes that a person that would use that kind of respect is telling the gospel truth. And it's such a pleasure to watch that happen.
This has been another episode of the Cheeley Law Review. Have a great day, everybody.